Hi, everybody. Welcome. I'm immigration lawyer John Khosravi. Thank you for joining us today. I'm coming to you live from Los Angeles, California, 6 p.m. Pacific time, where every week, every Wednesday at 6 p.m. Pacific, we come to you to take your questions, your general immigration questions, U.S. immigration questions, live so you can ask questions and do our best to just kind of generally go over everything that's there. I'm the managing attorney of the JQK Immigration Law Firm. I have some wonderful associates here who can help you as well. All you got to do is email us with your problems, and we can see if we can schedule a formal consultation. But that's not the goal here right now. The goal is to just talk about immigration. If you're interested in learning about marriage-based, fiance-based, that kind of relationship-based immigration, just download the Ultimate Marriage Green Card Guide. It's at marriageimmigrationlaw.com. Again, that's marriageimmigrationlaw.com. And learn about the process of getting married and getting a green card. Learn the best strategy. I just talked with a couple this week who had a family friend help them, and they were living outside the United States, and they filed the wrong forms. They filed for adjustment of status, which is filing a green card case in the United States, but they were overseas. So they wasted a bunch of filing fees. That case was eventually denied. Now, for 2 years, they have to restart the whole process from scratch. If they had the guide, it would have really helped them judge and know that, oh, this person is helping them doesn't know what they're talking about. So that's what it's there for. Definitely check it out and get the ball rolling on that. And also, if you're interested in learning about the extraordinary ability green card, some people call it the Einstein visa, the genius visa. It's not any of those. It's about having extraordinary ability. You're really good at what you do. You're one of the best. There's a green card for that called the EB-1A. And we have a weekly seminar for the rest of this quarter called the EB-1A Extraordinary Playbook, where you break down the A to Z of the process for getting the EB-1A. Just email me to register. It's Fridays at 10:30 a.m. Pacific time, 10:30 a.m. Pacific time on Fridays. Having said all that, one more thing, we give away free video consultations, 3 of them to be exact, per show. What you need to do is listen in and then click like and subscribe wherever you're watching this. In the comment section, all you need to do is write consultation. And my wonderful assistant, Katrina, will name a person every 10 minutes for the entire show. It's a 30-minute show, every 10 minutes of 3 free consultations, 15 minutes. We do it by video to talk about your case. And I think it's going to be really helpful. You're going to enjoy that and get some real one-on-one information. So we provide that every session that we have. But if you're tuning in now, definitely check it out. Just type in consultation after liking and subscribing. And then we'll name winners every 10 minutes or so. So with that, let's get the show formally started. All right, so a lot of it is happening in the immigration world. They're trying to make changes. There was one about the diversity visa, the green card lottery. President Trump, at the time, they had changed it so that if you're going to apply for the green card lottery, you have to have a valid passport and put that information there. They're switching up that guidance right now, so it's going to be very helpful for a lot of people that weren't aware. That's how strict the rules were for the green card lottery program, which a lot of people get. Technically, there's 50,000 green card lottery spots each year. Probably around 30 to 35,000 of those actually get the green card at the end. During COVID, it was even less than that. It was a very difficult time because the embassies were not processing cases. And right now, it's kind of a similar situation. It's hard getting an interview at many embassies. But I'm handling a couple of these cases, particularly for adjustment of status already in the United States, for example, on student visas. So that's one thing to do. If you are planning to, you like to stay in the United States, you're here, for example, on a tourist visa or even H-1B or something like that, if you could apply for the green card lottery, formal name is the diversity visa lottery, you should just put your hat in the ring. There's no filing fee for it. There'll be a lot of websites online when you type in like Google about the green card lottery. I'd say pay us $100, this and that. There's no fee to go in, but once you're approved in the lottery or win the lottery, then there's a bunch of fees you have to pay. But don't get scammed out of those. We have a question from Jordan, one of our regulars. Hey John, can working without authorization prevent you from getting a green card if you're married to a U.S. citizen if USCIS finds out? Well, they're going to find out because you tell them. So when you're married, first of all, you always have to be honest, so you can't lie. So the rule is this. If you're married to a U.S. citizen, unauthorized employment does not prevent you from getting a green card per se. If you're married to a green card holder, it can. And this is for adjustment of status, applying for a green card in the United States. If you go do it through the embassy, then that per se isn't a problem. But the rules are more strict if you're applying for a green card in the United States with Form I-485 adjustment of status, where they say if you have unauthorized employment, but you're married to a green card holder, getting your green card that way, they will deny your case. So if you're married to a U.S. citizen, they won't. However, there's other aspects to it. When you work in the United States, many times like corporations and companies, you have to fill out a form called Form I-9. In that form, they ask you what your work visa authorization, green card status, or citizenship is to see if you're authorized to work based on the immigration laws in the United States. Now, if you fill out that form and say you're a U.S. citizen, that prevents you from not only getting a green card, but most likely will lead to be deported from the United States. So say you're married to a U.S. citizen, and you should tell them, you got to be honest on the forms, and you tell them, normally they won't care, but if they ask for any previous I-9s and they see that, that's a big problem. Another problem that emerges is this. For example, you come to the United States on a visa waiver program or even a tourist visa, and you work without authorization. You go and then you apply for a new visa, and on that visa application asks, have you ever violated your visa status before? And you say no, but you have. And so now later on, when you get married to a U.S. citizen, even though previous unauthorized employment by itself is not a problem, fraud is. So if you fill out a visa application and you didn't tell them that you have violations, maybe if you told them, it'd still be okay. But if you don't tell them you have violations, that means you lied on a previous visa application. That's a misrepresentation or fraud, which should come back and be problematic later. It just pops in my head. There's several levels of complexity. And a lot of times when I ask clients, like, what did you say on this visa application 6 years ago, 3 years ago, whatever, they don't remember. And we have to do a FOIA request many times, a freedom of information request to get that information. And so it gets very complicated because I see online, just like the example I gave earlier when someone's family friend was helping them file for a green card. A lot of times, there'll be forums where I'll post and give advice on green cards. Someone inevitably comes up and say, oh, you're just trying to steal people's money. You're trying to scare them into hiring a lawyer. You're fraud. You don't need a lawyer. It's just paperwork. You don't know how many times every day I see and have people contact me because they made these mistakes. So when I hear people say it's just paperwork, frankly, majority of people are okay and they do it themselves. But there's a percentage that they're messed up like this, and they call me, and I literally get the calls every day. So I have a real understanding of the problems that emerge, even though it's probably a minority of them. It doesn't matter if it's a minority of people, if it's going to happen to you. So you really want to analyze the case and try to spot issues before they happen and try to prevent those, prepare for them, and just know what's going on. And that's what my job is as an immigration attorney, is to really kind of spot this stuff. And it's more than just the forms, because as you said, as you saw, like there's different forms for different prospects. If you're doing the U.S. or overseas, there's potential misrepresentation that pops up all over the place, and they're very strict on this interpretation. And then so there's more depth than that. So that's a long answer to your question. If working without authorization prevents you getting a green card, in most cases, if you're marrying a U.S. citizen, it won't. But we got to double check the other factors that can come into play. Thank you for your question. I'll say another regular asks, hi, John, how are you doing? I'm doing better, getting better. I had COVID a couple weeks ago. I wasn't too bad, but it kind of slowed me down, but I'm doing much better. Do you think if you make a mistake on your K-3 visa for your spouse, would affect your pending I-130? And how long is the process for the K-3? So what mistake is it that you made, Allison? So that's really important. But let's back up on what a K-3 I-130 is. So if you're a U.S. citizen, not a green card holder, and you file a form I-130 for your spouse, this is start the process for a green card. They have a thing called the K-3 application. So if you start that by submitting form I-129F, and you have both those going at the same time, if that K-3 I-129F, and sorry I'm throwing all these numbers out there, hopefully I'm not confusing people, but if that gets adjudicated first and approved first, then you have somewhat of a faster route for your spouse to enter the United States. But it almost never, ever happens. So with regard to the first part of your question, a mistake on a K-3, I didn't know what the mistake is, and maybe you could fix it by just telling USCIS. But realistically speaking, how long is the process of a K-3? There's only like 3 K-3s issued every year for the last 4 or 5 years. Before that, maybe there was 20. For every 10,000 marriage cases, there's 1 K-1 or K-3. I'm sorry. So how long is the process? There's no realistic answer to that. You probably don't want a K-3 there because it may speed up the ability of the foreign spouse to go to the embassy and get a visa to come to the United States by a couple months, if it ever happens. If they do get the K-3 into the United States, then you got to file for adjustment of status in America, which means more filing fees, more interaction with the government, all that hassle. So usually that's not what we're doing, except sometimes I've seen if you do file a K-3, it speeds up the adjudication of the initial I-130 petition. Not always, but I've seen it happen. So that's something we throw in there. Sometimes the clients really want it, but that's the best answer I can give you on that, most realistic answer. Thank you for coming on again, Allison. All right, another person, name is spelled acrylic. I'll just Romanize it. Mapesep asks, what happens if you separate, if they separate you in an I-751 interview, and the officer is not friendly and biased because of race differences, even though it's obvious we love each other. We can't live without talking to my wife even one day. But downtown LA, Los Angeles officer did not want to believe our relationship. The only difference between our case and other cases is race difference. 2 months after interview is completed, but 2 months after interview, there's still a message: interview completed, case must review. I don't know. I don't know the details of your case. I don't know how well you provided evidence, how well you presented and talked, and all that kind of stuff. There may be more to it, or it might just be a race. Now, if you're of different races, yeah, they are skeptical sometimes. But that's just one of many factors. I have a lot of mixed race couples who I handled. So it really just depends on how well you prepared, both the paperwork and joint documents, and how well you came off during the interview. It's not good, frankly, that's not approved. It could still be approved. With immigration, USCIS, you don't really know. But I don't have enough information to answer it. I wasn't there. And so it's not good that when they separate you, that's awful. Except for if you're in maybe Boston or something like that, where the field officer separates almost everybody. But from what I hear, or at least they get really strict and they in the same room they specifically have you answer separately. They do a weird thing in Boston, but overall, when they separate you, it's really bad. And what I can say is my wonderful assistant Katrina just named you as our winner of a raffle. So send me an email. Take a screenshot of where you're watching this so I can see your username is your username, the app that you're using, and email it to me at info@jqqlaw.com, our website, or email info@jqqlaw.com, and we can have a quick chat to see what's going on. I'm not sure I could do anything at this point other than help you prepare if you hired my office for a notice of intent to deny. If it comes, you might still get approved. So we just have to kind of see what's going on and what you did, and then take it from there. At this point, it's kind of like cleanup. Usually, you don't want to come at the beginning with these kind of cases, so prepared. And again, when people say, "Oh, why do we need a lawyer?" It's pretty simple. These kind of stuff happens, so you gotta. It's best to have a lawyer. And not every lawyer is going to care enough or pay attention or have it all together. So it's really just a lot of it's luck. But unfortunately, it seemed like you weren't too lucky at the interview. But maybe it's still okay. We don't know. But just as I said. For those just tuning in, we give out free video consultations. What you got to do, like this person did right here, is just like and subscribe and write consultation. And 10 minutes, and another 10 minutes after that, we'll announce 1 or 2 more winners of our free video consultation, 15 minutes. Just getting that screenshot for this person that asked. But if you're interested in generally learning about marriage-based immigration fiancé cases, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. And if you want to learn about the EB-1A Extraordinary Ability Green Card, the seminar is ending at the end of this month. So it's Fridays, 10:30 a.m. Pacific time. All you gotta do is email me and I'll register so you can tune in and be in that seminar, live seminar. You can ask questions and all that kind of stuff there, and you're gonna learn a lot. It's a lot of fun. But with that, let's go to some new questions. Slytherin says, how long is the estimated wait time for an I-601 waiver? Someone here from Mexico. Unfortunately, those are taking 1 or 2 years right now. Sorry, there's a big mosquito that's been killing me in this room. I just saw it right now. And I'm like, should I stop the show just to kill this darn mosquito? I'm sure you all feeling this too. It's summer and the atmosphere right now. They're just tearing me apart. I'm scratching my legs and my arms all day. I can't wait to kill it. Hopefully it doesn't look too graphic on the live show. But I'll go off that tangent. In 1 or 2 years, unfortunately, 601As are waivers for people who have unauthorized presence in the United States, accumulated it. That's a quick version of it. For those who know what it is, they know what it is. But the timeline for 601s and 601As is just getting worse and worse. Easily 1 or 2 years to get that adjudicated. Aruhan Nagam asks, I'm an international student working in a company in USA. My OPT company wants to file my green card. And I'm married and my husband is out of the USA. How long will it take and how does filing work? I'm being a little bit slow, but the employer could file for you. You may or may not be able to stay here. It depends on what country you're from, how long processing takes, all these kind of different factors. There's just a lot going on here. So that's too big a question for me to answer here. If your spouse is overseas, it's going to take forever years to get them in. So they really should enter the United States on their F2, possible, get F2 visa, come here. And if you're going to file for adjustment of status, file it from here. Obviously, you can't enter with the intent to file for adjustment of status. So I need to back that up. But If they were here, it would have been better, because if they're overseas and they're there, it's going to take forever. It's going to take years to get them here. You got to file Form I-824, and then you got to wait for the embassy, and it just becomes a mess. And so that's bad that they're outside of here. Now, if they apply for a visa, unfortunately, with the intent to come, student visa, which is a temporary visa, with the intent to really come here, file for a green card, it could lead to can be considered fraud and misrepresentation. Now, your employer hasn't filed for it yet. They may not, once they learn about how much it costs, they may not want to do it. So your husband may just file a visa just to come see you, because the employer may not file. But generally speaking, it's a big topic. You need to talk to a lawyer in private about that. Email the office to schedule a consultation. Your employer should be on the line too, because we need to talk with them. But whoever lawyer they hire could fill you in all these details, but it's just too in-depth and too case-specific for me to go into here. Sally asks, can a green card holder, a DUI green card holder, can they travel? Probably. You need a disposition on the case. We need to see what's going on. It's too case specific. I need to see exactly what happened. I need to see the court records, the police records, all that kind of stuff with regard to DUI before I can answer that. So it's too case specific. Generally, you will be able to travel, but whether you do now or not, and you yourself, without reviewing your documents, I can't answer that. Deco asks, I filed my son's visa class IR2. I recently changed to F11. Am I US and I am a US citizen? Why? They're probably the F11. What is the F11 category? IR2 is for children. See, F11. You have two windows open here. Yeah. Okay, sorry, let me close up one window. F11 visa. Generally, nobody uses these kind of category labelings. It depends on how old your son is. So F11 is the first preference category for adult children of U.S. citizens. So IR2 is immediate relatives. So your child was a minor, but they may have aged out. So we got to see what exactly you did, and maybe the Child Status Protection Act applies to you, and they mistakenly put you in the first preference category, which takes longer to process. So Deco, you really need to talk to the immigration attorney. Have your I-130, received or approvals there. I-130 approval notice. If you don't have it, the receipt, child's birth certificate. So we calculate the days, because they moved. Essentially, they're saying that your child became over 21 and they got out of the minor child of U.S. citizen category to the adult child of U.S. citizen category, and the difference in timelines is pretty dramatic. So be prepared for that. Deco, stick around. You might be our winner for our raffle. You need to talk to a lawyer in private and need to contact the agency to see what's going on. So that requires a review of your case. Unfortunately, it can be really bad because it adds a whole mess of time processing for your case. Safis Babu asks, I'm on an H-1B visa. My wife wants to study and work part-time in the United States. Will it be a problem if she applies for F1 instead of H4? No, this is not a problem. She applies for F1, but you can't really work part-time on an F1 student visa. Maybe you do on-campus employment. Maybe you can get a CPT or OPT depending on what you're studying, and then after you graduate. So coming with an F1 with the intent to work part-time, I'm not sure if it's going to be possible in the short term, but definitely you can file for an F1. I have people do that. It's a strategy too. So some people might be on H-1B, one spouse, and the other partner is on F1. So if the H-1B spouse gets fired and can't find another job, then they can switch and become an F2 dependent and stay in the United States. So that's a strategy that some people do actually. Marlene asks, how do I file an I-751 if I'm only separated, not divorced, haven't divorced yet? So that's a big topic. That's really private. We got to look at what's going on in your case, your timelines, but it's a more difficult case. You have to prove your relationship is real, but essentially you have to file for I-751 within the filing window time and hope your divorce is finalized by the time USCIS asks for your divorce certificate. If you don't have it, maybe you can play some games to kick the can down the road and ask for an interview, and hopefully have your divorce certificate by then. But not having a divorce certificate is going to be very problematic. So many times in cases, we want to hurry up to get the divorce certificate. But I don't know the details of your case and where you're at and what your relationship is and what kind of evidence and documents you have of your bona fide relationship. So I can't give that individual guidance. But I do want to, moving on, announce the winner. Deco Noor, my wonderful assistant Katrina, has chosen you as a winner for the a raffle or lottery for free video consultations. So if you're interested, just take a screenshot of where you're watching this, so your username is there and I know it's you, and email it to me at info@jqklaw.com, and we'll set up a time to have a quick chat. Having said that, for those who are just tuning in, we give away free video consultations during this live Q&A that we're doing. We have one more giveaway that's going to come out in 10 minutes, 15-minute free video consultation. All you got to do is like and subscribe and write consultation. My wonderful assistant, Katrina, will name a winner in about 10 minutes or so. Also, if you're interested in learning about marriage-based green cards, K-1 fiance visas, all of that, I have an ultimate marriage green card guide, 40-plus pages that breaks down the A to Z of it. See it for yourself. Download it at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. You'll be very happy downloading that, amazed at how much information is in there. And also, if you're interested in the extraordinary ability green card, the EB1A, and you want to get the A to Z of that, the whole playbook, well, I created a seminar, a live seminar called the EB1A Extraordinary Playbook. That's running every Friday at 10:30 a.m. Pacific for the rest of this month. It's quarter really, but this quarter is ending pretty soon. So catch that before it's done. I think you're going to really enjoy it if you're interested in this visa category. Having said that, let's go back to questions. Chinyera asks, hi, John. Good day. Well, thank you. How will one know where one's filer case is at when an I-130 form is filed in Texas but received from I-79, the receipt says California Service Center? What does that mean? They keep us guessing. So there's no real good way to know where your case is at, because when you file a case, you get a receipt back. It doesn't matter where you mailed it because they rearrange where the case is going to be processed, but you get a receipt back, and it'll write on the bottom left of the receipt notice the service center that they say is doing it. But they internally move stuff around, and they don't always tell you. Sometimes they'll send you a notice and your case is moved to a different service center, but majority of the time they don't. So you could call them and they'll say, actually, your case is in Vermont. But maybe when you call them, it's in Vermont, but after that it changes, and then, or they don't know, or they just give you the wrong one. It's so inconsistent, and the information is so badly given that when people ask which service center I am, there's no real good way to know, because they move around. Maybe they'll tell you what it is today, and then tomorrow they change it and they don't inform you. So, people want to know which service center they're at, because it helps them kind of go on USCIS.gov and check the processing times for that specific service center. But that's a waste of your time, because the timelines that they have on USCIS.gov I have found to be completely unreliable. So there's no point in knowing your service center, because the only use you may get out of it is finding the processing times. But because the processing times are worthless, there's no point in even caring about that. All you guys is your receipt in the case of processing. Hopefully you've filled out the paperwork right and submitted necessary evidence. And other than that, you just wait and see, because the timelines are so inconsistent. And you might have a service center who approves the case finally that's known for taking a year and a half, and they approve it in 4 months. Another service center, which typically gets cases done in 6 months, may take 2 years to do your case. It's that inconsistent, so I don't really bother myself. As an attorney, I don't even look at that stuff, and I recommend my clients don't bother as well. It says, if someone has asylum pending, so can they apply for an E3 visa? There's a lot of issues going on with just saying. An E3 visa is a special work visa for Australians. So if you have asylum pending and you could get an E3 for Australians, which means you're an Australian citizen, you probably don't have a good asylum claim, because not many people could claim asylum from Australia in the United States. But let's say you have a case like that. It does create somewhat problems, because you have to use your Australian passport. They might call into question that your asylum is real or not, your asylum pending. But let's put that all aside. Generally, yeah, if you have an Australian passport, you could apply for E3. Now, the main issue that pops up in these kind of cases where people have asylum case pending and they want to do work visas, they probably overstayed their visa at this point. The I-94 has expired, so they can't do change of status. And even if they could file change of status, because they have asylum pending, that may show immigrant intent. So you inevitably have to leave the United States and get a visa and come back. That could be problematic. It might destroy the asylum case. You might have had unauthorized presence for a certain amount of time that caused a 3 or 10-year bar. So it's really crazy. What you really got to do is talk with an immigration in private. It gets too complex to really go into detail about it here. Julius asks, I'm beginning my STEM OPT soon. Congrats. I work at a biotech startup. Can my employer apply for a green card and get it in 2 years? My employer is also applying for H-1B. Can they? I mean, it depends on what country you're from. If you're from India, no. And with timelines, probably 2 years work, but it could be longer. It's all over the place. You really have to see what's going on in your case and stuff. Your employer does have to be E-verified if you're going to do STEM OPT. Their lawyer will tell you, hopefully get your H-1B, and that'll hold you over anyways. But 2 years, generally in my practice, it has been possible, but things are getting delayed. There's several steps for that process. The first step, it keeps getting longer and longer. But if you're able to file for an I-485 adjustment of status, before your status expires, then you'll be able to stay here while the case is pending. So that'll solve that situation. But it kind of just depends. If your employer takes forever to hire the attorney and give them the paperwork needed, it might not get done. So when it comes to timelines, it's really hard to say 2 years from now what's going to happen with the world that we live in and all the differences and who's going to be president, what pandemic's happening, this and that. It's really hard to judge. You just got to do it. If they want to do it and they're interested in getting your green card, then you just got to do it and see what happens. Jorge asks, hello. So I responded to a medical RFE employment-based last week, thinking this is the last step of the green card, but today I saw an update online saying that another RFE has been sent. What could this be? I don't know. It could be anything. Just wait and see. Next question, Julius follows up. How do we know processing time for a country-specific green card backlog? There's a thing called the visa bulletin. So if you go to Google, you type in visa bulletin, and then you go to that Department of State website, and you click on the most recent month's visa bulletin. For employment-based case, you scroll down, not the first chart, not the second, but you have to look at the third and fourth chart, and that's going to be a general timeline depending on the country you're from. You'll see it. There's a difference between the third and fourth chart. And if you're in the United States and you want to do adjustment of status, you have to go find the equivalent of this on the USCIS.gov website to see which of these charts are being used at the time. As you see, it's getting complicated, explain all this kind of stuff. It won't help you right now because each month USCIS updates which chart they're going to accept for adjustment of status purposes in the United States. And by the time you can file Form I-485 for adjustment of status, they may have changed it where you can't do it. So it's just too much going on. So this is one of the things you just talk to a lawyer in private to really go over it. 29 C1 regulars. Good night, Attorney Khosravi. Hope you're doing well. Just touching base with you. God bless you, 29 Super C. Are you living in the U.S. now? Are you moving in full time? How's the work and all that kind of stuff? 29 Super C, one of our regulars, been watching the show over a year now, probably a year and a half, I'm guessing, and got a green card. We're really happy to be able to help you through that process. Cindy B asks, can one get dual citizenship from Guatemala if you're a U.S. citizen? If so, how do you file in Guatemala? We only provide U.S. immigration. The show is called U.S. Immigration Talk. I won't be able to help you with Guatemalan immigration, unfortunately. Key Media asks, hi, I filed from I-907 premium processing for my I-140 EB1. It was delivered to USCIS last Wednesday. How long did it typically take to receive a response from them? USCIS or in Texas? Well, they got to respond within a couple weeks. There's no typical time. It could go to the last second. Sometimes they go over, but 15 days average or something. I mean, 15 days is sort of the max of it, but I think they've extended this time. I haven't filed a premium processing case for some. Actually, my associate just filed the H-1B premium processing case, but I haven't filed one myself. They were going to change it to they have up to 30 days. I'm not sure if they did that, but just be patient and it'll get there. I don't remember all the details. But if you go to the Form I-907 website, it explains it all. I just haven't filed an I-907 in like a year or two, something like that. Shub asks, any fast processing on I-751? No. Fayeg asks, being an AA, how does this affect good moral character naturalization? It will become a big issue. Being an alcoholic used to cause denials for people. So it's going to depend on the, your background, any criminal history, and what the officer thinks of it. Going to AA and having letters saying you're going regularly and you're dealing with the issue, it could help you. But it's going to depend on the officer just the whole facts of your case. So just telling me you're an AA is not enough information for me to give you advice. That's why we need to have consultation. I need to see the whole picture of your life and what led you to go to AA. And there's probably some issues that popped up that led you there. So you might have some arrest history, DUIs, family issues, missing taxes, not paying tax. There might be a lot of other things that are associated with that addiction. So it's not something I can just jump into and tell you right now that this or that. And at the end of the day, it's going to be up to a USCIS officer. They're not as strict on this stuff as they used to be. They used to get into it. But I think there's a question about alcoholism on the N400. There used to be I rarely have a case where it's a problem, but I remember there was a question, are you a habitual drunkard? I think that was the way habitual drinker, habitual drunkard, how the question was on Form N400. Ahmed asked, they approved my I-130 for wrong adjustment of status. My wife, she's never been here. I filed I-24 and paid the fee again. What do you think? That sucks. Now, look at your Form I-130. If you filled it out properly, you could contact USCIS, contact your congressperson, contact the ombudsman, and let them know if USCIS is there and fix it. Other than that, yeah, I mean, you got to file the I-24 and hope for the best that it doesn't take forever. But I don't know the details of your case, so that's the general information I can give. I do want to announce our winner of our raffle lottery. I'll take one or two questions afterwards. But Julius, who you're asking about, EB2 and this and that. You're a winner for our raffle. You're still watching. Take a screenshot where you're watching this so I can see your username. Email to me at info@jqqlaw.com. You can schedule a private video consultation to get into your case a little bit more and talk about the details that you're interested in. After I know more about you specifically in a private session, can't share it all here, and we can take it from there. And this takes one question. Jack asked, at what stage in F2A filing are proof of relationship and medical reports required? If you're doing adjustment of status, the medical report is due any time from the time of filing towards your interview. If you're at the embassy portion, you have to do your medical right before the interview. Proof of relationship, my practice, we always file the proof of relationship with the initial petition, the I-130 petition. Some lawyers don't do that. I don't agree with that process. I think you should gather all the evidence and send it with the initial petition. But some lawyers don't, and you can bring it up to the interview date many times. If you're doing consular processing, you could bring it to the embassy if they approve your case without the proof of relationship. But I think it's best practice to include that all at the very beginning. Take one more question. Navpreet asked, what happens after taking fingerprints for I-751? You wait to get either an interview, approved, an RFE. That's about it. You may be able to file for citizenship in the meantime. You're married a U.S. citizen and you have a good I-751 case. And talk to the attorney in private, schedule a time at their office, just email me. But, it's been more than 30 minutes. I want to thank everyone who joined the show. We have a couple more questions, but sorry, come back next week, Wednesday, 6 p.m. Pacific time. We're here every Wednesday to talk U.S. immigration. Other than talking about my family, the second favorite thing I love talking about. And if you watch our YouTube channels or, see my magazine I publish or my other podcasts, 2 podcasts, I'm always talking about immigration, my TikTok, all this kind of stuff. It's a wonderful resource for the world that people come to the United States, and I really enjoy helping people through that process. My email is info@jqqlaw.com. If you haven't already, like and subscribe wherever you're watching this. And until then, I guess I'll see you next time. God bless. Be safe. Bye-bye.